The Trump White House filed an amicus brief. The Solicitor General, who's the White House attorney who normally argues cases for the White House in front of the Supreme Court, has filed this just yesterday or the day before. And normally I would have covered it in a normal show, but I haven't had time because I've been doing this. Not common for the White House to file motions with the Supreme Court in favor of the Second Amendment. I'm seeing lots of yeses and just a couple no's. Only one no. Nathan. Nathan is the one no. All right, Nathan. It looks like you're outvoted, Nathan. So let me do this. I'll open it up in this manner. Where am I? So I can use my my magic pen. Where is? Oh, here it is. Okay, so I need to stop this and open. Whoops, that's not the right button. Open this. Is that going to work? I'm going to make it bigger. All right, so before I make it bigger, in the Supreme Court of the U.S., Walford v. Lopez. This involves the Hawaii's ridiculous rules for concealed carry permits being challenged in federal court, now up to the Supreme Court and the White House. John Sauer, who's an excellent attorney, I'm expecting a lot from this. I haven't read this motion yet, this amicus brief, but I'm expecting good things from John Sauer. He always does very solid work. So let's jump into this, and I'll make sure I can see the court feed here, and I'll get my magic pen. Whoops, that's not the magic pen. This is the magic pen. Let's see if that's working. Yep. All right. Did that work? All right, so let's jump in here. Get to the meat of it as quickly as possible. How does that look to everybody? All right, looks fine. The United States has a substantial interest in the preservation of the right to keep and bear arms. Isn't that nice to hear from the White House and the proper interpretation of the Second Amendment? From the earliest days of the Republic, that's us, not a democracy, we're a republic, individuals have been free to carry firearms on private property unless the property owner directs otherwise. That's right. So this case is about Hawaii passed a law saying you can't carry a gun, even if you have a concealed carry permit, on private property unless the property owner affirmatively tells you you can carry the gun. The normal rule is you can carry the gun unless they affirmatively tell you that they cannot. They have to post a no guns sign. What Hawaii did was pass a law saying, no, you can't carry there unless they post a yes guns sign, which of course nobody is going to do, or very few people would do. In Bruin, this Supreme Court confirmed that restrictions on carrying firearms for lawful purposes, such as self-defense, violate the Second Amendment unless they fit within a discernible historical tradition. Yet after Bruin, 5 states, including Hawaii, inverted the long-standing presumption and enacted a novel default rule under which individuals may carry firearms on private property only if the owner provides express authorization, such as by posting a conspicuous sign allowing guns as opposed to prohibiting guns. Violations constitute misdemeanors punishable by up to a year in prison because most property owners do not post signs either allowing or forbidding guns. Hawaii's default rule functions as a near complete ban on public carry. A person carrying a handgun for self-defense commits a crime by entering a mall, a gas station, a convenience store, a supermarket, a restaurant, a coffee shop, or even a parking lot. Yet in the decision below, the Ninth Circuit upheld that rule against a Second Amendment challenge. That decision warrants the Supreme Court's review. Hawaii's default rule defies, indeed nullifies, the general right to publicly carry arms that Bruin recognized. Someone carrying a firearm for self-defense cannot run errands without fear of criminal sanction. In practice, only those who aimlessly wander the streets may exercise their right to bear arms. That's a Judge Van Dyke dissented from the Ninth Circuit opinion. Van Dyke's very good. You should definitely read his opinions, especially on the Second Amendment. That is no accident. The structure and operation of Hawaii's law reveals that the law serves no legitimate purpose and instead seeks only to inhibit the exercise of the right to bear arms. Hawaii's default rule applies only to firearms, not to anything else that a person might bring with him into a privately owned area that's open to the public. The rule also requires owners who want to allow guns on their premises to satisfy a special standard of clarity that does not apply when they consent to other conduct. Normally, it's presumed that you have license to do normal things, lawful things on the property, unless it's expressly prohibited. And the rule contains exceptions for police officer, retired police, state employees that would make no sense if Hawaii was genuinely trying to protect private property rights. Those exceptions only make sense if Hawaii were trying to limit arms bearing to a select favored group and to exclude everyone else. Certiorari is manifestly warranted. The Supreme Court should hear the case. The Ninth Circuit's decision conflicts with the Supreme Court Bruin recognition that the nation does not have a tradition of broadly prohibiting the public carry of commonly used firearms for self-defense. The Ninth Circuit also acknowledged that its decision conflicts with the Second Circuit's decision in Ontonek v. James. New York had a similar rule, that a similar New York default rule violated the Second Amendment. Sometimes they call these vampire laws, like a vampire can't enter a house without express permission. Eight judges dissented from the Ninth Circuit's refusal to hear this case en banc, correctly recognizing that Hawaii's law largely vitiates the right to carry arms in public and practically accomplishes close to the same thing as rejected in Bruin. 5 states, embracing more than a fifth of the nation's population, have already adopted this type of Bruin nullifying rule. And the decision below invites other jurisdictions in the nation's largest circuit to do likewise. This Supreme Court should grant the petition of a writ in certiorari and reverse the Ninth Circuit. Until New York State Rifle and Pistol Association v. Bruin, Hawaii maintained a may-issue regime for licenses to carry firearms. In practice, this was more like a no-issue regime. In 2018, the Ninth Circuit noted Hawaii had only issued 4 concealed carry licenses to private citizens in the past 18 years. And 1 county in Hawaii had never issued a single concealed carry license ever. In Bruin, the court held that the Second Amendment guarantees a general right to publicly carry arms for self-defense, and that may-issue licensing regimes violate that right. The Hawaii legislature responded by enacting Act 52, a statute that overhauled the state's laws governing the carrying of firearms. As relevant here, Act 52 establishes a default rule with respect to carrying firearms on private property of another person, purportedly to protect the rights of private individuals and entities to choose for themselves whether to allow or restrict the carrying of firearms on their property. The act provides that a licensee shall not intentionally, knowingly, or recklessly enter or remain on private property of another person while carrying a firearm unless the person has been given express authorization to carry the firearm on the property by the owner. That applies whether the firearm is concealed or unconcealed, loaded or unloaded, operable or not. An owner may allow firearms only by providing unambiguous written or verbal authorization or posting clear and conspicuous signage at the entrance of the building or the premises. Carrying a firearm without the requisite permission, punishable by up to a year. Act 52 exempts various groups from the private property default rule. Petitioners are 3 Hawaii concealed carry license holders and a gun rights advocacy organization. These are the people appealing the Ninth Circuit affirmation of this statute to the Supreme Court. Petitioners claim that various provisions of Act 52, including the private property default rule, violate the Second Amendment. The trial court granted a TRO, temporary restraining order, to the Second Amendment advocates, holding that the private property default rule likely violates the Second Amendment as it applies to property held open to the public. So they're not talking about like your home. The court explained that individuals have traditionally been free to carry firearms on such property unless they were affirmatively directed otherwise. The court determined that history did not support Hawaii's inversion of the traditional presumption. The parties then agreed to, and the court approved, a stipulation converting the temporary restraining order to a preliminary injunction, which was then appealed. The Ninth Circuit Court of Appeals affirmed in part and reversed in part. The court reversed the portion of the injunction prohibiting the vampire rule, citing 4 historical laws that prohibited carrying firearms on subsets of private land without the owner's consent, and 2 historical laws that purportedly prohibited carrying firearms on any private property without the owner's consent. The court discerned a tradition of arranging the default rules that apply specifically to the carrying of firearms onto private property. The Court of Appeals denied petition for a panel hearing and rehearing in Bonk. Judge Van Dyke, very good judge, joined by 5 other judges, issued a dissenting opinion in which he argued that the private property rule effectively nullifies the Second Amendment rights of Hawaiians and has no grounding in the historical record. Argument. The Second Amendment, which binds the states by virtue of the 14th Amendment, so the 14th Amendment, initially, the Second Amendment applied only to the federal government. The states could do whatever they want. After the Civil War, we adopted the 14th Amendment. It applies the Second Amendment to the states as well. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. In Bruin, this court, the Supreme Court, held that the Second Amendment guarantees ordinary Americans a general right to publicly carry firearms for lawful purposes, such as self-defense. Hawaii's private property default rule violates, in fact, functionally eliminates that right. Proposed Hawaii's private property default rule, the vampire rule, violates the Second Amendment. As this Supreme Court recently affirmed, a law regulating arms-bearing conduct complies with the Second Amendment only if the government can show that the law comports with the principles underlying the nation's historical tradition of firearms regulation. Why and how the regulation burdens the right are central to this inquiry. In other words, if there's a historical parallel to a modern gun control law, it has to be for the same purpose and carried out in the same method. The government bears the burden of showing that the challenge statute regulates arms bearing for a permissible reason. So the government has to prove their gun control law is constitutionally valid. The plaintiff does not have to prove that the allegedly Second Amendment violating law is invalid. The regulation must serve a legitimate purpose. They may not regulate arms simply to frustrate or inhibit the exercise of Second Amendment rights. Let's see. The government must show that the burden, the gun control law, fits within our regulatory tradition. First of all, concealed carry permits have no historical analog. So the very notion that you're required to have a concealed carry permit to carry a gun for personal protection is facially unconstitutional. In Bruin, there is a footnote, dicta, that says, well, but permits are okay. Why? All of Bruin is there has to be a history and tradition of the same restriction on the Second Amendment. There patently is not one for concealed carry permits. While that tradition prohibits certain narrow exceptions on who may carry arms, like not felons, where and how they may carry them, what types of arms they can carry, it does not permit laws that broadly restrict arms use by the public generally. The government may simply have not broadly prohibited the public carry of commonly used firearms for self-defense. Bruin struck down a state law requiring carry license applicants to show special need for self-protection. These decisions reflect the Second Amendment's original meaning. The founders viewed England's game laws, which disarmed the bulk of the people on the pretext of preventing poaching, as paradigmatic examples of abridgments of the traditional right to keep and bear arms. And that's from the Heller decision back in 2008. Noted the law's true purpose, the gun control's true purpose, were effectively to broadly prevent the people from possessing arms. Post-ratification tradition points the same way. Post-ratification of the Constitution, and by extension, the civil rights amendments after the Civil War. Let's see. Legislatures could enact reasonable regulations of the manner and mode of exercising a right, but could not subvert or injuriously restrain the right itself. That's from 1886. Precluded laws that under the pretense of regulating sought a destruction of the right, 1840. That doctrine also precluded laws that broadly negated the right, any civil right, but including the right to keep and bear arms. This court has applied similar tests across other areas of constitutional law, other constitutional rights. I'll skip past some of this. Hawaii's private property default rule, the vampire rule, violates those basic principles. Under the traditional property law, a person who enters private property open to the public does not need specific permission from the owner to carry a gun, or for that matter, to carry anything else. It is instead up to the owner to impose special restrictions on what members of the public may bring with them. Our Act 52 of Hawaii, the vampire rule, inverts that traditional default rule for firearms alone and not for anything else. A person who seeks to carry firearms on private property open to the public may do so under the vampire rule only with the owner's express authorization on pain of committing a criminal offense, a misdemeanor. The same person can carry all manner of other things, chainsaws, brass knuckles, megaphones, picket signs without express permission. That special default rule for firearms violates the Second Amendment in both why and how it regulates arm-bearing conduct. Hawaii cannot identify any permissible reason to adopt a special guns-only default rule. Hawaii claims they're trying to protect property rights of people. Singling out of firearms for the vampire rule has nothing to do with protecting property rights. For everything but firearms, Hawaii presumes the owner is welcome. The owner is welcome in on their property unless they affirmatively object. That includes individuals entering property open to the public presumptively may bring in bicycles, roller skates, protest banners, muddy shoes, dripping umbrellas, melting ice cream cones, open containers of alcohol, boom boxes, dogs, and many other things that owners might not want on their property. Only if someone wants to carry a gun must he obtain express authorization. That discriminatory rule manifestly seeks to suppress gun rights, not to protect property rights. It is no more constitutional than a hypothetical law requiring political campaigners and only political campaigners to obtain a homeowner's express authorization before walking up the front path and knocking on the door. Let's see what else. Contains exceptions for police that are inconsistent with an argument of protecting property rights. Hawaii's default rule also violates the Second Amendment in how it regulates the carrying of arms. The rule imposes a far more severe burden than precedent and tradition permit. In contrast to traditional gun regulations that focus on specific categories of people, specific places, specific types of weapon, or specific modes of carry, Hawaii's default rule broadly restricts arms in use by the public generally. And this is another Supreme Court gun decision, Rahimi. There's no special danger of misuse in Hawaii's rule. Applies to law-abiding people who have a carry license. It's not limited to sensitive places. Just about any private property is covered. Whether the property is generally open to the public or not, doesn't just restrict dangerous or unusual weapons, applies to any type of firearm, including those commonly used for self-defense. As a practical matter, the default rule operates not just as a broad restriction, but a near complete ban. Because most owners do not post signs, either allowing or forbidding firearms, the rule effectively means that the ordinary citizen may not carry firearms in any private property, even property open to the public. That restriction deprives individuals who want to exercise their Second Amendment rights of their ability to go about their daily lives. A person carrying a firearm under the vampire rule cannot pick up a cup of coffee, get lunch at a drive-through restaurant, stop for gas, enter a parking lot, go into a store, buy groceries, or engage in other routine tasks that require setting foot on private property. When asked where people could carry firearms under the New York vampire law, the governor of New York answered, probably some streets. The near complete ban is flatly inconsistent with Bruin and the long history underlying it. Bruin recognized an ordinary law-abiding citizen has a general right to carry arms for self-defense. Just as states may not limit that right to those who show a special need for self-defense, states may not limit the right to those who aimlessly wander the streets. Again, that's Judge Van Dyke. The Court of Appeals upheld the vampire rule on the ground that the states had enacted, previous states, had enacted a handful of purportedly analogous restrictions in the 18th or 19th centuries. But the court's approach is inconsistent with Rahimi, which held that the relevant question is whether the challenged regulation is consistent with the principles underlying our regulatory tradition, the why of the regulation. The Ninth Circuit's identification of a small set of poor analogs falls short of that standard. In fact, the Court of Appeals' historical analysis fails on its own terms. They point to a 1721 Pennsylvania law, 1722 and 1771 New Jersey law, 1763 New York law. So far, all of these are before the Second Amendment was ratified. So there was no Second Amendment civil right for any of those. And an 1865 Louisiana law, which was almost certainly race-inspired, almost all modern gun control law is originally intended just to keep firearms out of the hands of freed slaves, and an 1893 Oregon law, setting default rules for carrying firearms on private property. Under this Supreme Court's cases, however, the state bears the burden of showing that a firearms regulation rests on a well-established historical tradition. Hawaii cannot meet that burden by pulling scattered cases or regulations. In Bruin, the state could not satisfy its burden by identifying 3 colonial regulations, a single state statute, and a pair of state court decisions from the mid-19th century, the 1800s, again, around the Civil War, mostly racist gun control laws, and a handful of temporary territorial laws that were enacted nearly a century after the Second Amendment. The evidence cited by the Court of Appeals, 4 colonial laws, 1 mid-19th century law, and 1 law enacted more than a century after the Second Amendment, is similarly inadequate to justify Hawaii's sweeping prohibition. Moreover, most of the cited laws do not go nearly as far as Hawaii's, and so they are poor analogs. The Court of Appeals acknowledged that 4 of the 6 laws applied only to subsets of private land, such as plantations or enclosed land sought to prevent poaching, and likely did not apply to property that was generally open to the public. And although the court thought the 1771 New Jersey law applied more broadly, its text and context suggests that it too was limited to private land not open to the public. Such a narrow historical precursors cannot justify broad prohibition. That leaves the 1865 Louisiana statute that made it unlawful for anyone to carry firearms on the premises of plantations without the consent of the owner. Louisiana enacted that statute immediately after the Civil War, before its readmission to the Union. During that period, fears of an uprising among newly freed slaves prompted systematic efforts in the old Confederacy to disarm Black people. McDonald is another very important Supreme Court Second Amendment case. The Louisiana law cited by the Court of Appeals formed part of those racist efforts. As the state's Reconstruction governor later explained, this law, of course, was aimed at the freedmen, meaning freed black slaves. Far from supporting Hawaii's position, Louisiana's law is probative of what the Constitution does not allow. This court should grant review because its 8 justices on the Ninth Circuit, the minority, correctly recognized Hawaii's law largely eliminates Bruin, effectively nullifies the right to keep and bear arms. Bruin's explained the Second Amendment secures a general right to publicly carry arms for self-defense, and only exceptional circumstances would be allowed to abridge that right. The Court of Appeals turns the analysis upside down, upholding a law that prohibits public carry in general and that effectively limits the right to bear arms to narrow circumstances. Review of that Hawaii vampire law by the Supreme Court is especially warranted because Hawaii is just one of multiple states that have enacted such vampire laws since Bruin. Bruin identified 6 outlier states that have maintained the type of may-issue licensing regime that the Bruin Supreme Court struck down. 5 of those states, Hawaii, California, Maryland, New Jersey, and New York, then reacted to Bruin by enacting the type of vampire rules seen here. Those laws all include gerrymandered exemptions, showing their real purpose is to confine arms bearing to favored groups rather than to protect property rights. For example, it exempts prosecutors and judges. The Second Amendment doesn't apply only to prosecutors and judges, folks. Let's see. The Ninth Circuit concluded in a companion case that the California vampire law violates the Second Amendment because it allows firearms on private property only if the owner has consented in one specific way by posting signs of a particular size. But the court's distinction between what they say is the allowable Hawaii vampire rule and not the unallowable California rule strains the proverbial gnat while swallowing the camel. Again, that's Van Dyke. It's great words. The overwhelming impact of the 2 states' novel default vampire rule arises from the reversal of the presumption, not from the nuances of how someone might go about restoring permission to bear firearms on their property. Under the decision below, California need make only a minor tweak to its default vampire rule to resume nullifying the public carry rights of about 30 million adults. The Ninth Circuit decision independently warrants review because it conflicts with the Second Circuit in Ontonik. That was what reversed the New York State vampire rule. The Ninth Circuit acknowledged the circuit conflict, stating that its decision differed from the Second Circuit and that it respectfully disagreed with the court's analysis in the Second Circuit. Judge Van Dyke also noted the Ninth Circuit decision results in a split with the Second Circuit. Finally, granting review in this case would allow this Supreme Court to provide much-needed guidance to lower courts. In the foundational decisions of Heller and McDonald in 2008 and 2010, the court has granted plenary review and decided only 2 Second Amendment cases, Bruin and Rahimi. Without a developed body of precedent on which to rely, lower courts have struggled to interpret the Second Amendment. Rahimi provided valuable guidance, but multiple justices have recognized the need for more. So in the years since Rahimi, have many judges on the Court of Appeals and district courts. Let's see. This case is an appropriate vehicle for deciding the questions presented and for clarifying the principles underlying the Second Amendment. The petitioners have standing. The district court, the Court of Appeals, and the judges who dissented from the denial en banc all addressed the merits of that challenge. The preliminary injunction posture in which this case arises should not deter the Supreme Court from granting review. The Court of Appeals did not decide this case in haste. To the contrary, it issued an 81-page opinion nearly a year after the petitioners appealed. The court's decision also turned on the merits. The court explained, the court that affirmed the vampire rule, that it need not consider the equities because petitioners were not likely to succeed in challenging the vampire rule. And since the court's merits analysis all but foreordains the final outcome, It's not like the Court of Appeals is going to change their mind on this. Further proceedings in the lower courts would serve no useful purpose. This Supreme Court often considers constitutional issues in the context of preliminary injunction proceedings. No sound basis exists to treat the Second Amendment any differently, any lesser. Conclusion, this Supreme Court, should grant a petition for writ of certiorari on this vampire rule. John Sauer, Solicitor General, the White House lawyer who argues for the White House to the Supreme Court, excellent lawyer. Harmy Dillon, Department of Justice Civil Rights Division, excellent lawyer. Sarah Harris, excellent lawyer. Vivek Suri, I just don't know. I don't know who that is. I've not read any of their work. Of course, the real takeaway from all this is simply that the White House is doing this. The White House is filing this amicus brief in favor of the Second Amendment. You don't normally see this. Trump promised to support the Second Amendment when he came into office, and he's doing exactly that. And that is just awesome. Awesome.